Good afternoon. Greetings and welcome to the 2018 Alternative Dispute Resolution Competition. I am Dr. David Weiss from New Jersey City University's Institute for Dispute Resolution. I am humbled and honored to be able to present a few brief remarks on a new theory I have proposed for mediation modality. It is an innovation in mediation, and it is based on a theory that I will discuss in a moment. But first, I would like to thank and welcome the patron of this esteemed competition, Dr. Erica Veradi, Vice Dean of the Faculty of Law at Miskuch University, the distinguished guest of honor. I'd also like to thank the supporters and co-organizers of this event, amongst them the President of the Hungarian Chamber of Civil Notaries, the President of the Financial Advisory Board, the President of the Budapest Chamber of Commerce and Industry of Mediation and the Legal Department, and the representatives of the legal community who have supported this competition, specifically CESCOI, Attorneys at Law, and Walter Klauer, Hungary. Mediation, as we know, has been applied in the dispute and conflict stage of an agreement. And as many of you are familiar with, sits within the spatial of the ADR process. I began to think about how can mediation be expanded beyond the dispute and conflict stage of an agreement. I started this process by thinking about how business may want to adopt mediation and mediation principles, and what values or characteristics could be applied beyond the scope of the latter stages of the life cycle of a contract between two parties. I came up with a theory by exploring family businesses and published in a journal article last year where I looked at how family business over several generations fails because of the lack of information that flows between family members, family managers, and extrinsic factors that take place in the normal operation of a day-to-day business. I came up with a concept known as economic efficiency mediation, or what I like to refer to as EEM. What is EEM? EEM is a hybrid concept that is the combination of law, philosophy, and economics. Given the short period of time that I have today to discuss the theory, and I will leave the model for a different discussion, is to sort of focus and hone in on how the innovation of this theory can be applied. The centric purpose of EEM is to evaluate no different than you would in a traditional mediation process under the guise of a conflict or dispute information. But here we are really in the beginning of the contractual phase of an agreement. And what we're referring to here is the asymmetric information and how we can make it more symmetric, or equalize out the information that is being delivered between two parties. We use EEM in a way that optimizes the value of the confidentiality session with a specially trained EEM mediator. So what are some examples where EEM could be applied? One example is in a mergers and acquisition agreement, where the capital is being triggered at certain timetables, and the capital for the M&A agreement mandates that the information flow to consummate the agreement necessitates that a mediation session take place in order to extrapolate the information that is being provided between management and the deal team. Now, why would this be important? Because in the process of the deal team and that of management, there could be various interpretations of the information provided to optimize the best managerial decision-making conclusion to whether or not an M&A deal, or what we call mergers and acquisition, should take place. EEM, in a sense, acts as a hedge, but it also can be applied in other methodologies in the beginning of the life cycle of an agreement. One example would be a trade agreement. A trade agreement is a contract, but in this case, it may involve two nation states. We look at, currently, trade agreements through the ISDS clauses, which adopts a conciliation approach. Now, there are plenty of research and articles that have been developed on how to apply hybrid models of both facilitative and rights-based mediation to replace conciliation in these specific clauses. And I'm not going to discuss how that applies here today. What I am going to suggest is how EEM could be used in order to effectuate a better and more perfect trade agreement system. By applying notions of Ricardio theory, which addresses the idea that we need to balance information, we can look to a conclusionary result that ultimately produces what we refer to as a Peridot Equilibrium. So what does that all really mean? Peridot Equilibrium allows parties to wind up in a process that is more equalized in terms of the information being gathered and provided. So if we go back to asymmetric information, we're looking for a pathway or a process or a model, or in this case a theory, that will enable the information flow to A, take place, and B, to become more equalized in its effect. So if we think about the baseline of mediation beyond the scope of the mediator in terms of their training, their efficacy, their ethics, take a look at the confidentiality session and let's re-engineer its application. under traditional mediation processes, in the conflict stage, the confidentiality session is being used to exchange information between one party and the mediator, but with the ultimate idea or goal and objective to resolve a dispute between two parties. EEM is the converse of that process. It is a process by which the parties are delivering information in order for the mediator to assist as a facilitator and extrapolate the difference between the asymmetric information and the symmetry information, and then provide a pathway for parties to work towards a more perfect process of equalization of that information. EEM is one concept of innovation that I believe necessitates further discussion and dialogue of how mediation can help business and improve trade and commerce. It cannot be just one model that is used for conflict and dispute, but rather it should be used and adopted in order to assist parties in the business community in order to advance opportunities to promote trade and to deliver better opportunities in the private business sector in which there's better and more improved, fair, and equal balance. I also encourage, as part of this process, that each and every one of you think about how mediation can be adopted in other ways than just conflict, and what sort of new models perhaps one of you may come up with that is considered to be innovative to the process. I appreciate the opportunity today to present my theory and a little insight from a perspective of how mediation can be used within the greater business sphere. And I wish you all the best of luck in the competition for 2018. Thank you very much.